So welcome everyone to the Thursday meeting of the House Judiciary Committee. We got two matters on for the agenda today. I also wanted to bring to the attention of the members of the committee that we have a resolution, and I will offer it for signing by the other members. This is the 50th anniversary of the decision of N. Ray Galt out of the U.S. Supreme Court, which we recognize as being one of the landmark decisions addressing holding children in custody, and we thought we'd have a resolution adopted acknowledging this anniversary of the decision, and so that happened in 1967. And if you have an interest in signing with me, I would be happy to pass it around. To the right here first. And so we have a sign-up sheet. I don't see any names on it, but I'm going to leave it back out here. If you do wish to sign up, not a bad shot. We'll get you to do that. I don't know if Judge Crawford's around. I can't see him. Is he behind the post or not? No. More important meeting? Is that what you're telling me? All right. We're going to take up the first bill, which is Strickland. You got a bill before us, I believe, today, and this is House Bill 203. We'll ask for everyone to pull that up. We're working off the LC 391486 is the ER number. So we'll ask you to, if you'd like to, give us your explanation of the bill, the purpose behind it.
Thank you, Mr. Chairman, members of the committee. Everyone probably except Representative Hanson has heard this bill before. You passed this out of committee. Well, he was in subcommittee, so that's why I made the exception there. We passed this bill out last year, and I'll be honest with you, as I said in sub, I had too many bills and rules, and this one wasn't sexy enough to get out of rules last year. But I have bring it back again this year, and what we're dealing with is issues with restricted covenants, and more importantly, with after you get past Section 1, issues we have now that the recession is over, trying to rebuild condominium complexes and also rebuild and finish subdivisions. And so it was two bills last year. This committee decided to combine into one bill. So Section 1 is a little bit different than the rest of it. Section 1 deals with the statute of limitations you have on violations of restricted covenants. And this is from case law to try to distinguish, or we're now codifying, distinguish between a continuing violation and a one-time violation, when you're going to start the clock or when you can sue. The example being if you put a fence up, once you put that fence up, the clock starts to tick upon you putting that permanent fixture up, versus you violate a restricted covenant, you park in the wrong spot. Every time you park in the wrong spot, the clock starts to tick again. So it seems like common sense, but we had a suggestion by our appellate courts to codify this as well. So that's cleaned up the difference between a continuing violation and a one-time violation of restricted covenant. Section 2 goes under the Condo Act, and with Section 2, under current law, if a condominium wants to expand, wants to add to the number of units, for example, they have a right to do that for up to 7 years from when the condo is constructed.
Declarant does.
Declarant, that's correct. And currently we have the issue of condos were started, the declarant goes under, or they can't finish what they're doing, but it's in the original declaration that it's going to be a certain size. 7 years has passed. There's no way to go back and revive that 7-year period. This actually allows homeowners with a 2/3 vote to go back and revive that after 7 years has passed. The catch is it takes 2/3 of the voting people who own the units, but also you can only go back to what was the original declaration. You can't go bigger than what you originally had. And I'll keep moving if you'd like.
Please, well, you've actually got three different sections pertaining to much the same thing happening as far as the expansion. The other two apply to, was it subdivisions?
That's correct.
And one townhomes or something?
One deals with subdivision, one deals with POAs, property owners associations.
Property owners association, okay.
And so the
That's
other,
right that way.
and the other sections, and this came obviously from your suggestion when I approached you about this a couple of years ago, Chairman. One of the issues I had back home is neighborhoods that, because of recession, they were half built, and they want to go back and finish the neighborhoods, and you have issues. One in particular where you have a pavilion that is sitting by an entrance of a neighborhood that's owned by a bankrupt developer. HOA was never turned over to the owners in there, and they have no way, without going and asking for equity of a court, to actually get that homeowner association turned back over to them to take care of common area property. And so we took what we already had in existing law, which is what you see with Section 3 here in the Condo Act already, and we had a mechanism for folks in subdivisions to now go back and petition the declarant who hasn't done what's listed out here in this bill. You see in, like, for example, Section 3, lines 71 through 86. And you haven't paid property taxes, you haven't properly turned over your neighborhood, you're not maintaining something, you haven't called the meeting of the original members association. You go and give notice to the declarant who hasn't done this. If they don't do it within 30 days, you have a way to go to court and petition a court to basically require them to do this or turn over a neighborhood to homeowners. And it's an expedited process. We have a limited discovery in this as well to make it a quicker process. And you see that with sections 4 and section 5. Section 4 adds that to property owners associations in the code. Section 5 adds that to planned subdivisions. And in section 3, we're taking the existing law we already have there and adding to it lines 85 and 86. Failure to pay property taxes on common area in a neighborhood, and also in lines 67 and 68, we're making sure you can't basically contract this right away. You can't say in your articles that you have no authority to go and do this.
Right.
So that, Mr. Chairman, is a bill. I'll be happy to answer any questions.
All right, any questions of the presenter? I want to go back to your section 1. I just, as I read it earlier, I was wondering about the language. I'm sure the same language we had last year. I guess the benefit of having years looking at something. But on line 17, we start with an allegation. When an allegation is based upon a continuous violation. And I wonder about the use of the word allegation there as opposed to when an action is based upon
claim or action.
A claim or an action is based upon a continuous violation of the covenant. I'm not sure what allegation might mean. And you can sort of be accused, which would be an allegation, but I just wonder what anyone else has thought about that as far as the use of that word.
And you hear a lot of non-lawyers going in front of this committee and saying, well, I'm not a lawyer, but, well, I am a lawyer, but I'm not sure why we used the word allegation there back when we drafted this. I'm not sure if that's consistent with other areas.
That probably should have said it to be more clear, when an alleged violation
An alleged,
upon a
Is
continued
based upon a
violation.
continuous, okay.
sounds like a good amendment.
When an alleged violation is based upon a continuous violation of the covenant. What about when an action is based upon a continuous violation?
Could it be an action?
When an action, because we use the.
When an enforcement action.
Any other thoughts of members of the committee? We've got a lot of good wordsmithers around here. Yes, sir, Mr. Holker.
Mr. Chairman, I just got a doggone notice from my HOA, and they used the term complaint, so I don't know if that's a term of art or not. I needed to paint my mailbox and get it up to speed,
Paint your
which I did. I did.
Took care of that.
All right.
Very
So when a
handy.
complaint is based upon a continuous violation.
But I don't know if that's a term of art. It's just
Yeah.
how they defined it.
Term of art. I don't think, Mr. Chairman, I'm Brian Gardner.
You gonna come up here and speak with us so we can have you on your mic? Got millions of people around the world
They're all
watching us.
Fix your tie. Your wife's watching.
Thank you, Mr. Chairman. I don't believe it's a term of art. We use the term allegation to get at the same issue, complaint. So I think any term that you believe adds clarification would be fine in that section. I do a lot of HOA work.
Yes, sir.
I'm with Dunlap Gardner LLP. I represent about 300 HOAs, and I don't think there would be a concern using either complaint, alleged violation, or some term like that to make it clear.
Complaint seemed to be a pretty good term.
I think that would work, Chairman.
Okay, now we got when an alleged violation or complaint.
Is the only thing with, using the word complaint as being a legal document that initiates a case versus when your right to bring an action accrues. That sounds better.
When alleged violation or complaint.
I think that
I can go with that. So we will have that in a moment. We'll go to the bill for action. Is there anyone else who wishes to address the committee on House Bill 203? If not, we will close off further public comment, and the bill is now in the breast of the committee. Do we have a motion?
Do pass.
We have a motion do pass. Any discussion on that motion? Do we have any amendments? Yes, sir. We have an amendment. Mr. Fleming.
Mr. Chairman, line 17, after the word "and," insert "alleged," and after the word "allegation," insert "or complaint."
An alleged allegation.
An alleged violation. Make that after the word "and," assert alleged violation or complaint. Strike
Okay.
allegation.
An alleged violation or complaint.
Yes, sir.
So the striking allegation, insert alleged violation or complaint. And it would read, when an alleged violation or complaint is based upon a condominium violation
Continuous
of the
violation.
covenant, a continuous violation, thank you, of the covenant, resulting in an act or omission, the right of action shall accrue each time such act or omission occurs. Everyone understand the amendment? Any further discussion on the amendment? We'll call a question on the adoption of the amendment. All in favor signify by saying aye.
Aye.
Opposed, like sign. The amendment is adopted to the bill. Is there any further amendments? If no further amendments, we'll call the main question. Main question is adoption of House Bill 203 as committee substitute as amended, LC 391486ER. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Thank you.
You've got your bill coming out.
Thank you, Mr. Chairman.
Thank you, gentlemen. We next have a major piece of legislation, which is House Bill 159.
Mine wasn't major.
Major by size, only by,
15
Hey.
minutes do pass. Let's see how
only by size.
Sure.
That's House Bill 159, so we have LC 297393 ERS. And I might add, in your folder, you will probably find a synopsis which gives sort of an overview of the important salient points of what we're doing here as far as the changes in by this bill. Mr. Reed, you want to introduce your guest with you, and we will have you present the bill?
Yes, sir, Mr. Chairman. Thank you. I have with me Ms. Jessica Gordon, and she is the human database on Georgia adoption. And
Thank you, Ms. Gordon. Glad to have you with us.
I know that there's been a lot of time that has gone into this. This is really 18 months since I got involved, and really 2 legislative sessions and a lot of hours. Probably not quite as many hours as space flight, but not far behind either. But I do want to thank Ms. Gordon and also recognize there are GCAL, Georgia Council of Adoption Lawyers members here. Will y'all please stand? And thank you for being here.
Great.
Thank you for your work as well on this too.
I forgot your name. Ruth Claiborne. That's right, Ms. Claiborne. Glad to see you again.
The Mr. Chairman, this bill was filed last year as House Bill 881 and received a couple of subcommittee hearings in Chairman Caldwell's subcommittee at the time, and then decision was made last year to hit the pause button and take a step back, and because of the extensiveness of this, to really take a long, hard look at it. And over the summer, there was a tremendous amount of work done. I'm going to try to get out of the way so that Ms. Gordon can do what needs to be done here. But I did want to say a special thank you to Chairman Fleming and Representative Oliver. Have specifically put a tremendous amount of time into this. And Ms. Travis, is she here?
She stepped out. I think she's supposed to be back here for this bill, but she's not in the room
Okay.
at the moment.
she over the summer, she really took it on herself to even take a piece of this and the forms part, which the latter, the probably the second part of your bill is all forms, so it's not.
She's arrived.
It's 100 pages, but about 50 of it are forms. And Ms. Travis over the summer really worked hard independently to improve these forms, and it is truly one of the most remarkable things to come out of this is that it's a much more user friendly. It's very form based practice, as you all know, and it's so much more clear for the non-lawyer and for lawyers as well. But this bill represents a substantial improvement to the adoption code. We have worked consistently from the beginning with the agencies, with the Barton Clinic, with the Council of Superior Court judges, with DFACS, and we are committed to continuing to do that from this point on until this matter is completed. But I believe Ms. Gordon is going to help us with a 30,000 foot perspective on some of the policy that we're doing here, and then whatever shall please the committee.
Thank you. Ms. Gordon, let me ask you one thing before you start. Do we look at anything as far as any type of uniform proposed bills or statutes, I should say, as to areas of adoption, or is this pretty much patterned by what we need to do in Georgia?
Chairman, thank you. I would say that we're not looking at a uniform code, but many of us are members of of a national adoption group where we have attorneys who are the top of their field in adoption. It's the American Academy of Adoption Attorneys, and we have consulted with them on what is in their state and compared ourselves to them to see what the national trends are. But mostly, I would say too, it is the collective experience of the attorneys that are in GCAL and their representation of working with everyone on the adoption triad and representing them, the adoptive parents, the biological parents, and the children in adoption, and then working with the other groups that Representative Reeves mentioned, that we've come to the product that's in front of you.
Okay. Why don't you take us through and give us that 30,000 overview of it?
Okay. This bill seeks to reduce the minimum age for a single petitioner from 25 to 21. And the changes are on page 4, starting at line 102 in the bill. I'm just going to hit on the major policy changes, and again, happy to take any questions.
You might, when you go through these changes, what was the basis behind the thinking of the need of change for those areas?
Yes, sir. We're proposing this change in order to provide judicial discretion to judges as to the appropriate age to adopt on a case-by-case basis and in the best interest of the child. The minimum age of 25 for a single petitioner was placed in the code in 1927. There never has been a minimum age for married petitioners. GCAL fellows have had a number of cases in which a single petitioner had not yet reached the age of 25. Examples include a foster parent under 25 petitioning with the consent of DFACS to adopt a child already in a foster parent's home, or an adult under 25 adopting an orphan sibling or cousin. This change would allow judges the discretion to decide if an adoption under these circumstances is in the best interest of the child. Another policy change is that the bill seeks to provide a very small exception to the requirement that the petitioners must be 10 years older than the child who is the subject of the adoption. And this is only in step-parent and relative adoptions. You can find this on also on page 4, lines 103 to 104. In step-parent adoption petitions, the age difference just sometimes does not exist. And that's the same also in relatives. For example, a GCAL member was retained to represent an adult service member whose orphaned younger sibling was in need of a parent, and the service member could provide a stable home along with health insurance, education, other military benefits. In such situations, the alternative is for the child not to have the opportunity of a legal relationship with either, in that case it was a relative, but it could also be the same case for a step-parent. Again, judicial discretion would apply as to the maturity of the petitioner and the best interests of the child, but we would like to make an exception just for relatives and step-parents so that if they have a child who is already in their lives because they're related or they married into it with the child, that we would have the opportunity to see if an adoption would be in the best interest of that child. Another policy change you can find on page 4, line 106 to 109. The bill seeks to eliminate the 6-month residency requirement for adoptive parents to petition to adopt. This change would enable a petition for adoption to be filed more promptly in the case of Georgia residents, and to specifically allow a non-resident of Georgia to petition a superior court to adopt a child who was born here and placed with a non-Georgia resident pursuant to the Interstate Compact on the Placement of Children. This allows Georgia to see to the permanency of children who are born here in Georgia, and it also eliminates the need for those Georgia parents to have to execute choice of law affidavits waiving their rights under Georgia law so that their child can be adopted in the state of residence of the adopting parents that the biological parent has chosen. It also brings Georgia into line with many other states, including our neighbor states, Florida, Tennessee, North Carolina, South Carolina, and Alabama. And there are many others as well. Another policy change that we'd like to accomplish with this bill is that the bill seeks to update the path for the domestication of a foreign decree of adoption and provide a path for the adoption of a foreign-born child for whom the Georgian parents were only able to obtain a guardianship or a licensure. It's not the same as a guardianship as we have here. But the proposal seeks to cover the realities of international adoption law. So this 1988 was written before a lot of international laws were passed on the adoption of children. And we're trying to streamline that and also make it much easier for when a Georgia couple, has already jumped through so many hoops in federal law to do everything that they need to do to bring a child in, and we want to make it easier and less complicated for them to be able to domesticate that adoption in Georgia when they come back. The bill also seeks to add the option for an individual over the age of 18 signing a surrender of parental rights to waive the 10-day right to revoke his or her surrender so that the individual may elect to have the surrender become final upon signature. This is in sections 19.8.4, 5, 6, and 7. And it's repeated over pages 4 through 16 of the bill.
Do you know what page that is? What page?
So it starts on page 4,
Mm-hmm.
and this change is repeated.
It is? Okay. That's been something that varies from state to state, too. Over my last time
yes.
I had many years ago experience with that was a Tennessee case where they had I think 30 days.
Yes, and that is in the major minority of how most states do it, to have a 30-day non-waivable period for your surrenders. The majority of states now have surrenders that are permanent upon signature.
Mm-hmm.
A lot of other states allow for a revocation period the way we do, but they allow for it to be waived. And that's the most common. And that's what we're seeking to do. We're seeking to kind of find the middle ground among all the states. And we're doing it because it helps birth mothers who have thought about this decision throughout their whole pregnancy, and they finally get to the point where in Georgia, and I believe every other state, you have to wait until after the baby's born to sign the surrender.
Mm-hmm.
So they've gotten to that point, they've given birth to the child, and they've made an adoption plan. And once they sign the surrender, it takes a lot of courage to get to that point, and they would like it to become final. Right now, they're forced to have that 10-day revocation period. We don't want to take that option away from them to be able to think about it for another 10 days and revoke, but we want them to be able to have the right to waive that 10-day revocation
So it'd be two
period.
separate documents. One would be the surrendering of the parental rights, sign that. But then if you don't give up, if you want to give up your 10 days rights, you'll sign a separate document.
Well, actually, this is one of the improvements to the forms that,
No.
that Legislative Council made. It's within the surrender of rights
Mhm.
where they can choose if they're waiving their rights to that revocation period.
Okay.
Our bill also seeks to provide for limited payments of living expenses for birth mothers in non-agency adoptions. You can find this on page 32, line 1116, and also on page 54, lines 1932 to 33. Currently, Georgia code already allows for birth mothers to receive living expenses in Georgia in association with agency adoptions. This change would authorize independent attorneys to dispense living expenses as well for a limited period of time in connection with private independent adoptions. Many times, due to work condition hazards, physician-directed bed rest, etc., GCAL attorneys have been contacted by birth mothers who wish to make an independent adoption placement, but they needed living expenses for food, rent, utilities, and usually it's towards the end of their pregnancy. Current law, as I said, only allows for living expenses to be dispensed in agency adoptions. Not all birth mothers choose to go through an agency. And so, as it stands now, birth mothers who need living expenses are either forced to work with an agency in Georgia or they're forced to place their child out of state with adoptive parents who live in a state that allows for reasonable living expenses in independent adoptions. Or sometimes they're forced not to pay the rent so that they can make the placement choice they want in Georgia, but then they risk losing their housing in their last trimester. So this change would just give the option back to birth mothers to make an adoption placement the way that they choose.
What about medical?
Medical is already allowed.
Part what?
So in current law, adoptive parents can pay for medical expenses.
Okay, so they were limited as to how much they could pay otherwise beyond the medical side. I
Right,
guess from
so,
a policy standpoint, one of the things that has driven that language was that it not be misused as a way of paying for acquiring that child.
absolutely. So we
how
would
we
never
answer
want
that?
it to appear that it's child buying or anything like that. And I can assure you that what we've put in here has all the safeguards to make sure that it wouldn't be. This is very,
Well,
very
tell us those
limited.
safeguards.
Excuse me?
Tell us those safeguards.
So the safeguards are that, first, it would only be for the last few months of the pregnancy. It couldn't be for the whole pregnancy. But the biggest safeguard is that every time an attorney files an independent adoption in Georgia, we have to give a full accounting of every penny spent and dispensed in the case. So we even now need to prove what we've done and what we've paid out of our trust accounts. And there is judicial oversight of that, making sure that we're only paying for what's legal and within the guidelines of the law. This would allow us to do reasonable living expenses, which in practice is considered rent, utilities, phone payments, so that they'd be able to have their cell phone still hooked up, and food.
Mhm.
And that's it. And we would give an accounting of exactly what the rental payment is, how much we paid, and for what time. All submitted to the court. Sorry.
Just to carry a little further thought-wise, that would be true if they came to you at a point in time as the attorney for the adoption. I would think many of them are not gonna happen until really the last month or so, perhaps, of the time prior to birth. And you may have had a running time, so what do you do as far as looking at the time prior to their coming to the attorney and saying, we're gonna do a private adoption, we've got a mother that's willing to give up the child to us, and what do you do as far as inquire, well, have you paid anything to this mother prior to this time? Is that required, or what do you?
Certainly,
have
as an
as far as
attorney, that's something I would ask and make sure that no payments have been made, because I do think that could go towards a lot of impropriety and child buying and that type of thing. And I wouldn't take a case at all when that
Understand.
had been
We-
happened. So,
We got a lot of lawyers out there, though.
right.
You wouldn't, others might.
Well, I
Just trying
would
to
submit
think what
that would be
doing.
against the law to take a case where there's
Is it
already been.
against the law?
I would submit that it
Uh-huh.
would be.
Is there anything done as far as, I guess, the court making or
I mean, if they
having the
did,
obligation to inquire about it?
there are two affidavits of accounting that go into independent adoptions. Also, the petitioners need to submit what they've paid out. I think that there could be a claim potentially that they paid out money prior to hiring an attorney and they didn't realize what the law was, and I think they could make that case to the judge, but that would still absolutely need to go in front of a judge. And they would,
So they've been paying the mother $3,000 a month or something, which they felt was taking care of these things, but maybe more than actual cost involved. They still have to report that, and the attorneys will require the affidavit of the adopting parents?
yes,
Or
sir.
is it just, who makes affidavits? The adopting parents, as well as does the mother giving up the child make a statement of any kind?
Yes, and there is a mother's affidavit that's required of a mother who is signing the surrender document. It's an accompanying document that is required under current statute and would be under the bill as well.
Okay.
And within that affidavit, she needs to say whether or not she was given money in order to give up the
Say
baby.
she needs, is that required by the law to be contained in the affidavit?
Yes, it is a question in the affidavit
Okay.
currently.
Forms are in here
Yes,
that you use for that purpose, right?
yes.
Okay.
Now, if her rights were being terminated, we wouldn't go to it, but if we're talking about a mother who is surrendering her rights, she is always asked if she was given payment.
Okay, so that's required by law, and it's in the forms
Yes.
that we're saying, you, the mother of the child, as a part of what you're doing in giving up this child for adoption, you need to sign an affidavit that says you have not received any compensation other than what's permitted by law.
There's criminal penalties too in section 191024 that you have to provide the information about the inducements that were given and received and such.
Yeah, I'm just concerned, this is the, I think, public policy issue we gotta be sure is not overlooked with adoptions.
Thank you.
Page 87, yeah. Notice to, okay.
Yeah, but I'm 3004.
Okay,
Yes, and that's current law that we ask them every time, and they need to fill that out.
I didn't mean to interrupt you, that is an area that I think we need to be clear that we're not changing so drastically that there's a loophole.
Yes, sir, and we've absolutely talked about that amongst ourselves and talked with other groups as well. And I can tell you that most other states make it even more broad, and agencies are permitted to do it at any time. We made it just the final trimester that living expenses could be dispensed in an independent adoption, and we did want to make it very narrow for the chairman's concerns as
Good.
well.
Thank you, didn't mean to interrupt, but glad we clarified it. Hope I didn't make you lose your place.
And those were the major policy considerations that we wanted to talk about today and bring to your attention. If you have any questions about any of the other changes that we're proposing, happy to answer any questions.
I'm interested in also the fact that apparently we've gone to great length in putting forth the forms. And is this a change from the bill last year? Do we have most of these in there
No,
last
sir,
year?
this is an improvement.
Okay.
We currently have all the forms in current law, the forms were in the bill proposed last year. The improvement is that Legislative Council worked further on the forms and made them more concise, better laid out, more readable by a layperson, and understandable.
Good. Thank you, Ms. Travis. Any questions from members of the committee of the presenter? Ms. Reed, you want to add anything to it?
I just want to say again, thank you. There's been a tremendous amount of vetting of this, and I hope the committee will favorably consider this today.
Okay. Ms. Oliver, you satisfied with it?
Mr. Chairman, I'm impressed with the quality of work. Over my long legal career, I've done adoptions, and I feel like that this bill reflects the change and the modernization of adoption practice as it goes forward now. The internet and the ways in which relationships are found and determined and changed and decisions are made about placement of babies for adoptions has just fundamentally changed. And I think almost all of that's for the better. The two big policy considerations from my perspective, the elimination of the waiting period for the birth mother and the allowance of a individual lawyer to provide expenses in addition to medical expenses, I think that simply reflects a greater sophistication and a greater awareness and improvements in the law based on the modern practice. But I'm mainly impressed with the quality of work that's gone on in this, and I'm respectful of that.
That's good to hear. Anyone else have questions or comments? Tell me about that form again. Now, the language is recognizing the mother's giving up this 10-day period of cancellation. Is it set out in larger letters, bold letters, something that makes it more? Page 65?
That's an example.
Because my concern is you're going to say it before the mother, say, here, if you just sign this, everything's resolved.
Yeah, you actually have to choose one, A or B.
So you have to go through checking off with
Well, you have
putting
to-
initials, signature?
yes, actually signature on that one,
Okay,
and it spells out. that you-
Separate
you can
signings.
only choose one, A or B. You're either retaining in paragraph A, and then it sets out specifically the time frames in which you have to change your mind.
mm-hmm,
And then in B, you're actually waiving it.
okay,
That's embedded in
That's
each
good.
of the forms.
It also explains it on page 61. That's the beginning of a surrender. And it explains exactly what they need to understand before signing it. This is what should be read to them by the counsel or the petitioner's representative prior to signing.
mm-hmm,
They're told, and it is in all caps, that they could waive their right to revoke the surrender.
right. Now, these forms will be not published by the probate court in one. Where will someone be able to obtain the forms? You just go to the code, find your form, and then
Correct.
prepare it yourself?
It's embedded in the code.
I know.
Exactly. So
So now I'm an attorney, and I do one adoption every 10 years, and somebody comes to me for an adoption. I'm gonna look at the code and say, here's the form I use, but I gotta type it out, prepare it, as opposed to having some place where I can go and pull it off the shelf, say, here's my set of forms. Just trying to see how's it being done.
yes, that's how it's currently done and currently contemplated, that the attorney would draft their own surrenders. Again, it's really a cut and paste. You could
Mhm.
you could cut and paste straight from doing a LexisNexis search from the form. I think it's a good suggestion. We do CLEs every year. We could put
Software
Forms.
together.
and potentially software. I'm not sure how
I
it
just
was
mean
first
having-
started in
having
the
something you
probate
have as
courts with that, but
Thumb drive with all the forms on it would be a super thing to do, but That
that's
lawyer
something we could
have a-
certainly look
have a way
into.
to buy it, yeah. Okay. Ms. Gordon, thank you.
Thank you.
Appreciate you being with us today. Anything further from members of the committee, Ms. Gordon or Representative Bart Reeves. If not, okay. That's one of the standing jokes he and I have. We appreciate it. Anyone else wish to address the committee? I know we've got some fine lawyers here that do this work and type of adoptions. Anyone else wish to address the committee on the bill? Ms. Claver, you want to say a word? You
No, we're all here in favor of it.
just packed.
Mr. Chairman, and the one comment I would make about the forms, the difference with the probate court is that it's designed to be a user-friendly court for pro se people, and adoption, pro se adoption is not really encouraged, so I love your suggestion of making it more readily available to attorneys, not so much putting them on a shelf in the self-help arena.
Right. Thank you.
Thank you, thank you.
Yes, ma'am. All right, we will cut off further public input to the bill, and we appreciate you being here. Do we have a motion?
Motion do pass.
Motion is due pass. And seconded. Do we have any discussion on the motion? Any comments? Do we have any amendments? There being none, the chair will call the main question, which is a motion due pass House bill, I lost my place now. By substitute. It is came out of committee of substitute. LC 297393, House Bill 159. All in favor signify by saying aye. Opposed, like sign. Motion carries. So we'll go forward, Mr. Reeves, with our new adoption code in Georgia. Thank you, sir. Do we have anything else to come before the committee? I have the, I'm sorry. His Honor Matt Crawford is with us today. Came in, you know, Mac served in this committee with me for a number of years. Sorry, he can pull his rank on me anytime. Glad to have you with us today, Mac. Good to see you, sir. We've got the resolution passed around. Everybody have a chance to sign that, and we'll get that filed. Appreciate it. And with that, we will adjourn the committee meeting.